Today's date is July 23rd, 2014. The time is 10:44 a.m. Will the court reporter kindly swear in the witness?
Raise your right hand, please. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Good morning, Mr. Chandler. My name is Bob Sweetapple, and I'm an attorney. I am one of the attorneys who represents the town of Gulfstream. You're familiar with the town of Gulfstream, I take it?
I am.
Right. And we have not met prior today, is that correct?
That's correct.
Okay. You contacted me with regard to allegations of conduct of Mr. O'Boyle and the O'Boyle Law Firm and offered to provide a voluntary statement. Are you here voluntarily today?
I am.
Okay. By the same token, I know that you have indicated to me you spoke with your attorneys, private attorneys, before coming here. Have you spoken with your own legal counsel before coming?
I have.
All right, and have you elected to come here without legal counsel?
I have.
Okay. And as I understand it, for some period of time you worked for a foundation or an alleged foundation by the name of the Citizens Awareness Foundation?
Yes.
Okay. I do not want to have you do anything that would invade any privilege that foundation has by way of a lawyer-client privilege with any law firm, any Florida law firm or any law firm. If in the course of my questioning or your providing information to me, you come to a point where that may be happening, please stop, all right? And stop me if that ever occurs, because I don't know what your statement is going to consist of in its entirety by any means.
Okay.
By the same token, I know that you have spoken with attorneys, because you told me that. You have a right to a privilege with regard to anything you've discussed with attorneys. You have the right to waive that. You've indicated to me that the O'Boyle Law Firm has or does represent you with regard to a couple of public records requests. You're the client, I take it, in those. If you choose to waive the privilege, that's your prerogative. I'll leave that to your decision and discussions with your attorneys.
I understand.
Okay. I thought the best way to handle this would be for you to just tell me what it is that you wanted to make the town of Gulfstream aware of, keeping in mind that the town does have, I believe, 2 cases with the Citizens Awareness Foundation. I'm not counsel in those cases at this time, but I think you are aware of that fact.
Yeah, I don't know how many there are, which is part of the reason we're here today.
Okay, but you were aware that the foundation has filed suits against?
Yeah, I just don't know how many.
Okay. I don't know either. I'm just going by what I've heard.
Right.
Right. Maybe the best way to handle this, if this is comfortable for you, is just to have you describe for me the matters that are of concern to you, that you want to make me aware of. And if you don't mind, if I have a question, I'll interrupt. And if it's messing up your train of thought, just let me know and I'll wait. But if not, I'll try to follow up, and if something's not clear, I'll get you to answer it. And then when you're done with your statement, I'll probably have some questions for you.
Sure. Feel free to interrupt anywhere along the way.
Okay, please.
Yeah, as you know, I think, I went to work. I was hired as the executive director of the Citizens Awareness Foundation, Inc. And the genesis of that relationship comes from an email that I received from Marty O'Boyle. And I got an email from him on January 4th of 2014. And he invited me to meet with him regarding what became the Citizens Awareness Foundation, Inc. He invited me to his home in Gulfstream, where I had been previously. I actually met Marty sometime in 2013, I believe, early part of the year. My original meeting with him was with Barbara Peterson, who's president of the First Amendment Foundation. She was having breakfast with him, thought that I might have some interest in talking to him because as she understood it, he was interested in open government issues, as I am. nothing really significant happened at that original meeting in West Palm Beach. We actually met at I think it was a Holiday Inn in West Palm Beach near the airport. We met for an hour or so, and that was sort of that. And then sometime after that, I was contacted by Marty's attorneys asking for my input on a number of public records issues they were having in West Palm Beach or Palm Beach County. So I traveled at their expense down to West Palm Beach, and again, this was sometime in 2013. I think it was probably around the fall. And I reviewed a very large number of public records requests they had made. It was a very casual relationship at that point, and we sort of stayed in contact because we seemed to hit it off. He's a very, very, very pleasant man, very charming. And then on January 4th of 2014, he asked me to come down to West Palm Beach, or to Gulfstream, to meet with him, which I ultimately did. And we exchanged a series of emails leading up to that. He invited me to stay at his home. I met him at his home, believe it was it would have been around January 22nd, I think, maybe, in that vicinity. We met at his home, and he asked that the two of us meet privately, and that's when he first told me about his vision for creating a foundation. And the idea, as I understood it, was that he wanted to provide to me meaningful economic resources so that I could be more effective in my civil rights advocacy. And I have for a number of years, probably 8 or 9 years, worked full-time as a civil rights activist, and my primary focus is open government issues. I work with a number of civil rights organizations. I'm very active in a number of minority communities, trying to help people better understand their civil rights with respect to access to public records and open meetings. So what Marty proposed essentially was that he would create, or I don't want to say he would create, that he would provide the economic resources for the creation of a foundation that would be originally a not-for-profit, and that the intention was to immediately begin the process of filing as a 501c3 with the IRS to become a nonprofit. When we talked, his original proposal was that I would be hired. We didn't really have a title at the time, just that I would be hired to head up this organization, and that he would pay me a salary, or the foundation would pay me a salary, which he would. My understanding was he was going to provide all the economic resources. He would be the sole donor, at least in the beginning, and that he would pay me. That I would be paid a salary. That I would be provided with a car, and then I would be provided with a budget to engage in activism and advocacy for open government. We negotiated over a period of several days some of the economic arrangements, and ultimately what we agreed to is that I would be paid $120,000 a year, that I would have a very unclear budget. I repeatedly asked what my travel budget would be, what my, what could I plan to spend on advocacy, and the response I kept getting was whatever it takes. He said that he was prepared to spend $300,000 or more, whatever it takes to make it possible for me to do what I do. My understanding, what I believe our agreement was essentially that I would be, where for years I've been working for free, making very, very, very little money, that I would now have a salary, so I wouldn't have to worry about how to feed my family or keep the lights on, that I would be provided with meaningful transportation, and that I would basically be given the resources to do what I have been doing and just be able to do more of it. And what that looks like is meeting with student groups on college campuses to inform them, encourage them to exercise their constitutionally protected civil right to access to public records and open meetings, that I would meet with minority groups, that I would become the public face of this organization and encourage people to exercise their rights. In addition to that, I would continue to do what I've been doing for many years, which is to audit state and local agencies for their compliance with the Public Records Act. Since I've been doing this since 2008, I have personally been the plaintiff in probably something on the order of about 200 public records lawsuits, and that's not an exact number, that's just an approximation. I have won 99 point something % of those cases, and about half of those I've done pro se. So because of that, I've appeared as an expert witness in a number of public records cases, and whether it's deserved or not, I don't know, but I guess widely regarded as something of an expert on the issue. Because of that apparent expertise, I think Marty felt that by allowing me to have the resources to go out and do more of the advocacy that I've already been doing, that as a result of that, unfortunately, sometimes litigation is necessary. The idea, obviously, was that his son, Jonathan, had already started, not long before this meeting in January, what I understood to be an interstate law firm, the O'Boyle Law Firm. And it was pretty obvious that the idea was that if Marty gave me, through this organization, significant economic resources to do what I was already doing anyway, that as a result of that, there would probably be public records litigation that would have to be referred to some law firm. And it seemed pretty obvious to me that the intent was that as a result of the economic support that I would receive from Marty through this foundation, that his son would have public records lawsuits. Which that in and of itself did not make me uncomfortable. I did think at the time it was necessary to put in place some safeguards to be sure that this was above board and that there were no ethical or potential legal issues. And there were a number of things that I insisted upon. There were a number of conditions that I put on the arrangement that I had with Marty. And just to kind of give you a sense of the chronology, we met, I think it was on January 22nd. It was a Wednesday. And by the following Monday, which I believe was January 27th, the CAFE, the Citizens Awareness Foundation, Inc., was actually incorporated. So we agreed to my relationship with a yet undefined entity, which was created on the 27th. And I literally went to work the same day that the foundation was created. And I was frankly very excited because it had been a long time since I'd had a regular paycheck. My wife was very enthusiastic about the prospect of having a regular income. My real enthusiasm was not for the paycheck, it was for the resources to do what I perceived to be real, meaningful, valuable advocacy for the public. Some of the safeguards that I insisted upon was that, number one, the foundation would be utterly and entirely independent of any influence from Marty and any influence from the O'Boyle Law Firm. And to further that concern, or to safeguard that concern, part of the arrangement was there would be an independent board. In addition to there being an independent board, that I would have absolute sole discretion with respect to the commencement of open government litigation. I would be the only person that made a decision about whether the foundation was going to engage in litigation. I would be the sole person with authority to retain law firms. Part of that would be that I would obviously serve at the pleasure of the board, but the board was to give me discretion about making arrangements to engage with law firms, and that I would be the only person acting on behalf of the foundation to make decisions about settlement or litigation strategies. The other condition that I placed on our arrangement was that I would be have sole discretion about where I went, and that there would be no, as I put it, enemies list. That there would be no particular agency or entity or person that the foundation would litigate against, and that there would be no agency that would be off limits. So I didn't want there to be any kind of an arrangement where I was expected or directed to go after one particular entity, or that I would be told that there was somebody I couldn't go after. When I say go after, what I mean by that is to these audits that I engage in, and which I still do, is I literally will show up at a publicly operated agency or contractor that acts on behalf of a state or local agency, and I'll make a public records request for non-exempt public records and see what happens. And if they comply with the Public Records Act, I'll congratulate them and thank them for doing the right thing. And if they violate the Public Records Act and the facts of the case are very clear and unequivocal, then I will oftentimes litigate to enforce the public's right to know. Unfortunately, in Florida, the only meaningful enforcement of the public's right to know is civil litigation. That's an observation that both the courts and the governor have made. On the very first day, on January 27th, I went out and started doing my thing. I started in South Florida, in Miami-Dade County, and I think I went to 12 agencies the first day, and of the 12 agencies I went to, there were 10 that were just egregiously violated the Public Records Act. I mean, black and white, unequivocal violations of the Public Records Act. And I ended up referring those first 10 cases on behalf of the foundation to the O'Boyle Law Firm.
Can you tell me who at the O'Boyle Law Firm?
Yeah, I dealt with Jonathan O'Boyle, and I dealt with Ryan Whitmer. I also dealt with, there were two other attorneys that were working there at the time, Merritt Hanna and Giovanni Mesa.
Okay, and did the foundation and the law firm enter into any type of written agreement, retainer agreement of any sort?
No, none that I'm aware of. In fact, that was an issue that I repeatedly raised. I cautioned them about the potential ramifications of not having a fee agreement or at least an engagement letter for each individual case. My concern was that under 119.12, that entitlement to attorney's fees might be in peril if they didn't have a written fee agreement, but they didn't seem to take that very seriously. To my knowledge, there's never been one.
So that your advice was to have a written fee agreement?
Yeah, and just so we're clear, I never give legal advice to the public. I am very frequently engaged by, not always for pay, but very frequently engaged or contacted by attorneys asking for my input on public records issues. And that was a very frequent occurrence with the O'Boyle Law Firm. In fact, one of the very first things I did within the first week, I actually did for lack of a better term, a public records seminar. There were a couple of civil rights activists that I've known for a while who came down. They were from North Florida. They came down and sat in, as well as Giovanni Mesa, who was a new attorney at the time and didn't really have much experience with open government litigation.
So as far as you know, the foundation has not been a party to any fee agreements with the O'Boyle Law Firm at any time?
Not that I'm aware of.
Okay. All right, please continue. I'm
Yeah.
sorry.
No, that's quite all right. So my time was spent the first week going out and actually doing audits of public agencies. I contacted, in fact, I did a press release. I was contacted by a number of media outlets. I'm frequently contacted by reporters who very often are frustrated in their attempts to get access to public records. I somewhere in this general time frame of late January or early February, I actually spoke with one of my attorneys, Greg Thomas. In fact, I met with him in Tampa, he and a couple of his associates, to kind of lay out exactly what the arrangement was. Because what I was concerned about was not only whether what we were doing was legal, I believe that it was. I was also concerned whether it was ethical, and I believe that what we were doing was ethical because of the safeguards I put in place. But I was also very concerned about the public perception. What I did not want to do is to be involved with something that appeared to be a mechanism for doing nothing more than generating lawsuits. Unfortunately, my experience has been that when you do meaningful public records, open government advocacy, a lot of public agencies either just don't understand what their obligations are, and because of that they violate the Public Records Act or the Sunshine Laws, or I think it's fair to say many of them deliberately do it. So as a result, it's really common to get litigation. It's sort of part and parcel to what I do. If I were to audit 10 publicly operated agencies, municipalities, police departments, sheriffs, on average about 60% of those would comply with the Public Records Act. The other 40% just wouldn't. They just wouldn't produce the records. If I were to audit 10 state contractors whose contracts explicitly make them subject to the Public Records Act, 9 out of 10 would just violate the law. So I think my perception was that Marty, not unfairly, perceived that by giving me the economic resources to do what I was doing, as a result of that, there would be litigation that came out of it, and litigation has got to go someplace. One of the issues that I've had over the years with private attorneys is their capacity to handle the amount of litigation that comes from what I do. You know, the cost of filing fees and attorneys being willing to take cases on a contingency basis has always been a very significant limiting factor to the amount of litigation that I've been involved with. In spite of being involved with literally hundreds of public records lawsuits, I've only filed on a tiny fraction of those that could have been filed, just because I simply didn't have the resources to litigate the other ones. When I asked Marty about that, you know, what's your, I think the way I put it to him was, what's your tolerance for pain? How much money are we talking about? I mean, how many?
For what, for filing fees?
For filing fees.
Okay.
Yeah, how many, you know, and his response was, well, how many do you think you would get? And my immediate response, just sort of a knee-jerk without really thinking about it, 100. And he sort of like, yeah, it doesn't seem, so what? I mean, that doesn't seem like very many. And you know, so I don't remember the exact words, but something to the effect that you know, 100 in a year is not very many. And I said, no, 100 a month. I mean, if I went out and did what I do full time, it would not surprise me if what resulted were 100 cases a month. And his response, and I was really sort of shocked, pleasantly surprised, his response was, yeah, sure, that's not a problem. So then I was like, again, just trying to get a sense of the depth of the water. What if there were, that'd be 1,200 in a year. What if there were 2,000 in a year? Sure, no problem. What if there were 3,000 in a year? Sure, no problem. Whatever it takes. And it was both frustrating and very winsome, frankly. Every time I asked the question, well, you know, how much can I spend on travel? Whatever it takes. Well, how much can I spend on advocacy? Whatever it takes. All right, well, what if I want to sponsor, the First Amendment Foundation does every year, they do sunshine seminars all around the state of Florida, and they're free to the public, and public officials go to them. Can I sponsor those? Sure. Well, can I buy hundreds of sunshine manuals, which cost $18.95 a piece, and I just want to give them away? Not ask for a penny, just want to give them to anybody that wants one. Sure. Buy all you want. I mean, it was this sort of blank check, do whatever you think you need to do, you do what you do, and I think the understanding was that as a result of that, cases would flow to the O'Boyle law firm. But one of the safeguards that I insisted on was that I would be able to refer cases to other law firms, because I did not want this to be the kind of arrangement where all I was doing was generating lawsuits for anybody, but particularly for one law firm. My understanding of our arrangement, what I insisted upon was I would go do what I do. You'll provide the economic resources for me to do that more effectively. And if litigation flows from that, that's fine. If litigation doesn't flow from that, that's fine. This is not about going out and getting lawsuits. This is about doing meaningful advocacy, knowing that historically, unfortunately, litigation very often comes from that. I made it very clear that I would not have any kind of a quota for lawsuits. My income, and this was a very critical part of it, my income was completely unaffected by litigation. I didn't get paid any more or any less whether we got lawsuits or didn't get lawsuits. I got no more resources or no fewer resources whether we got lawsuits or didn't get lawsuits. This was a very agreeable, amicable. Marty and I, as I said, met at his home, literally sitting next to his pool. And then after that, we went and met Jonathan, his son, for dinner. And we kind of talked more about the details of this, and away we went.
Okay, so Jonathan was involved in the early meetings with regard to forming this foundation.
Yeah, my sense of things was that leading up to my trip from Lakeland down to Gulfstream to meet with Marty, I also had a number of phone calls and email exchanges with Jonathan O'Boyle and Ryan Whitmer, who Ryan was as I understood it, was his law partner. And I'd met Ryan before, a very charming guy, very nice guy. And they were very excited. I've dealt with a lot of lawyers over the years. I changed lawyers like most people change socks. My perception was here are a couple of young guys. They're setting up a law practice. They seem very excited about open government litigation. And my understanding is they had done a little bit, not very much. The big change for me was that I was dealing with people that had real meaningful economic resources. Because I kept asking the question, not only to Marty, but to the attorneys, what is your capacity? Because when somebody says to me, and I've had attorneys ask me this before, well, I would love to do litigation, how many cases are we talking about? I will ask attorneys, well, what's your tolerance for pain? How many can you handle? And they almost always are shocked by just the sheer volume of cases that are out there. There's just almost a limitless number of cases when it comes to open government because there's just so many violations of the law.
Okay, now I'd like to just interrupt there.
Yeah.
Because you didn't start working, the foundation wasn't even formed until the 27th of January.
Right.
So you met with Jonathan O'Boyle prior to the foundation being formed.
No, we talked on the, yes and no. He and I spoke on the phone, Ryan and I spoke on the phone, we had a conference call, we exchanged emails. We met with Marty and I had dinner with Jonathan, I believe it was on the 22nd. And the foundation wasn't actually officially incorporated until the 27th. There were a number of reasons for that. One was Marty had originally proposed that we use, and I don't even remember the name of it now, there was some not-for-profit that had already been created. My objection to using that was that Jonathan was actually on the board. And I thought it was entirely inappropriate for an attorney who might represent the foundation to be on the board of the foundation. I thought that clearly showed a potential conflict of interest.
What was the name of that
I
not-for-profit?
have no idea.
And had it just been recently formed?
No, my sense was it had been created, it had actually been existent for some time, but they had never really done much with it.
And did you discuss with Jonathan that would be a conflict?
I did.
And with Martin?
Yes.
Okay.
Yeah.
All right. And at the time that you were having the dinner and talking to Jonathan or communicating with him prior to actually going to work for the foundation, did he disclose to you that he was not a member of the Florida Bar?
I don't recall. I had met with Jonathan and Ryan a couple of times back in 2013. We had dinner. It was sort of a social talk shop kind of thing. And I remember that both of them, I think Jonathan is licensed in Pennsylvania, New Jersey, and I think Ryan passed the bar in New York maybe. Both of them had just sat for the bar in Florida. I think Ryan had gotten his law license in Florida maybe in November, and Jonathan was still waiting he had passed the bar, but he hadn't yet gotten licensed. I don't know exactly when I learned that. I don't remember whether that issue came up or not.
Before the foundation was formed, did Ryan or Jonathan tell you that they had formed the O'Boyle Law Firm?
Yes.
And did they tell you they had opened it, whether or not they'd opened it in Florida?
Yes.
Okay. And did you discuss with them who was working at the O'Boyle Law Firm prior to your forming the foundation? Did Jonathan ever tell you that he was working there?
I don't remember him ever using those words. It was very clear to me that I was talking to the two principals of the law firm. Mm-hmm. I mean, that seemed very, very apparent. It was never presented to me as Ryan is the only attorney that I'm dealing with. I mean, this again goes back to the issue of, which capacity, how many lawsuits were we talking about?
All right, we'll get into that. This is very early.
Yeah.
I'm just trying to nail
Yeah.
down the facts concerning your dialogue prior to your becoming employed by this foundation.
Yeah, part of the issue was, and I am sort of perpetually on the hunt for attorneys who can either assist me as a plaintiff, but more importantly, who are available to assist citizens when they have issues with public records access. I get contacted by citizens all the time, almost every day. And I'm not a lawyer referral service. I don't ask for anything in return. I don't get any kind of a kickback. I don't get any kind of a referral fee. It's just, there are people who need help, and most of them don't have the resources to hire an attorney and wouldn't know where to start. So before I even met with Marty, so between the 4th of January when I first got this invitation to come down to see him and the 22nd when I went, I had several telephone conversations with Jonathan and Ryan. Part of those were the initial conversations had nothing to do with the foundation. It was, hey, we're starting a law firm. If you want us to take cases, we're available to do that. We kind of talked about, working together in that capacity, either them representing me or me potentially referring clients to them, again, for no compensation on my part.